Moving on to our next myth. This one states that, if a work has entered public domain, the author will lose out on all the benefits and rights associated with the work. For example, moral rights. So the author will lose out on all the moral rights related to the work if the work has entered public domain. Is that the right way to go about it?
So that's actually not true. See, moral right, it refers to your paternity or maternity rights, which is
Right.
your right to get credits, and your right to basically restrain any usage which would be prejudicial to the honor and reputation of the authors.
Correct.
Right. So Section 57 and Section 38B of the Copyright Act, they deal with the moral rights or the special rights of the authors and the performers respectively.
Right.
Now, the 2012 amendment to the Copyright Act, interestingly, made an amendment to Section 57, which deals with the special rights of the authors. And it deleted the portion which talked about the moral right being only with respect to, until the term of expiry of the copyright.
Right.
So the legislative intent here seems to be very clear that moral rights ought to survive even the passing away of the authors. And so with respect to, say, films and cinematograph films and sound recordings, the producer is the author.
Right.
So a producer can technically restrain, somebody from making any modification or distortion which could be prejudicial to their honor or reputation. And likewise, even for author of underlying works.
Nice.
But it would be an interesting challenge with respect to, to see how legal heirs might establish reputational damage on behalf of the deceased author when making claims, for the moral rights violation. That would be interesting to see.
Agreed on that.
Thank you for that, Anushree. That is very helpful to know.